can I see you for 1 second? We are present in case number 23 CR 1095, State of Ohio versus Brandon Barfield. We're here on a motion to terminate the defendant's community control sanctions. The defendant was placed on community control sanctions to this court just this past year in February, 6 months ago. Motion to terminate the community control sanctions has been filed, alleging 2 separate violations. We're scheduled today for a probable cause hearing. Defendant's in court with his attorney, Mr. John Patika. Mr. Patika, what's the defendant's intention at this time?
Good morning, Your Honor. Mr. Barfield would like to waive his probable cause and final hearing, accept responsibility for his misconduct here, and resolve the violations today.
Barfield, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated 2 separate rules. The first is Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. And it's alleged that you reported on Friday, August 23rd, that you were using cocaine. It's further alleged you violated Rule 10, which requires you to provide urine screens when directed by your probation officer, and you're not to have in your possession a device or substance to simulate a urine sample or bring in a urine sample with you. And it's alleged that on August 26th that you attempted to use fake urine to pass a urine screen. Now you have the right to have a couple hearings regarding these allegations. The first is what's called a probable cause hearing, which is a hearing where the state would be required to present some evidence that would suggest you probably committed these violations. You also then have a right to have a final hearing on the merits, which would be a hearing where the state would have to prove the actual merits of what they are alleging. That would be on another day and time to give you time to prepare if that's what you wanted to do. You could have either or both of these hearings, or you can waive the hearings and plead guilty to the violations. And your attorney has indicated, as you just heard, he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If, in fact, that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I sent you to prison, it could be 9, 12, 18, 24, 30, or 36 months in prison. Do you understand the potential penalties you face if you are found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final a probable cause hearing or the final hearing, or do you want to waive the hearings and plead guilty to the violations?
Waive the hearing, plead guilty.
Very well, then as to the allegation that you violated Rule 8 by using cocaine, what is your plea to that?
Guilty.
As to the allegations you violated Rule 10 by bringing in fake urine, what is your plea to that?
Guilty.
Court will accept your plea of guilty, find that you did violate your community control sanctions. Mr. Patika, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say at this time?
Yes, as the court's aware, Mr. Barfield is VA eligible. He participated through treatment at the VA. These violations make it clear that he's relapsed. He served 4 years in the Navy where he was an electrician. He has twins that are going to be 2 years old in December. We'd ask the court to consider a placement in NeoCap, give Mr. Barfield an opportunity to get clean and sober.
Barfield, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
No, Your Honor.
No? I'd like to know why you don't think you should go to prison. Because when you were here last time and you did this pre-sentence report, you said you're never going to be back here again. If I'm given the opportunity, and this is last time given an opportunity, if I'm given the opportunity, you will not see me again in this courtroom. Well, here you are. I'm seeing you right in front of me. You said you'd like to get probation because you don't want to miss any more of your children's lives. Well, apparently that's not the case. So why shouldn't I send you to prison? You got a break to begin with the charge that you had, and they reduced it to give you a chance to get on probation, and you couldn't last a few months. You got out of the VA, and I went along with what you requested. I modified your sentence last time because you didn't want to do the local programs here. I let you go to the VA hospital. You got it on April 26th. In May, June, 4 months later, you're trying to perpetrate a fraud upon the court, bringing fake urine in. You should be charged with a crime for that. Tell me why you should go to prison.
I don't really have an answer for that, Your Honor.
Well, I don't either. I was hoping that you would be able to give me one because that's what I think should happen. It doesn't appear that you really want to get help. You're putting in the bare minimum effort that you need to do to escape by probation, but you're not doing what you need to do for yourself to get better. You're not doing it for the right purpose. You're doing it because I'm requiring you to do it and your probation officer's requiring you to do it. You're not doing it because you want to get better. You do the bare minimum. If you don't want to get help, we're wasting our time. There's other people that want those beds.
I do want to get help, Your Honor.
But what happened here?
I made a mistake.
Oh.
Who
are you using with?
I was with a group of people on Friday the 23rd. A friend who I thought was a friend presented it to me, and
Who was that?
I'd rather not state his name.
I don't care if you'd rather say he's not going to get in trouble. I'm not going to get him in trouble, but I want to make sure you're not hanging out with this guy anymore. What's his name?
His name's John.
Was it?
John.
All right, it doesn't really limit it for me. John what?
I don't know his last name. I don't, sir.
John, last name unknown. I don't really believe you there, because if that was the case, then what would be the harm in saying John? You're not putting anybody out there. What's his name?
I don't know his last name.
Where'd this happen?
We were out in Parma at a bar called Pounders.
You working?
Yes, I do have a job, yes.
Where were you working?
Buyers products.
When did you start working there?
Uh, Started about 2 months ago.
You have some information on that?
He didn't tell me that.
When you were here last time, when you talked to probation, you just reported you didn't understand. You feel stupid, wish you'd never done it. You didn't understand the magnitude of what you were doing, or you never would have done it. Well, that doesn't sound too credible as well, because I think you would have understood the magnitude of it when you were here last time, and when I explained to you what the potential penalties were if you violated your probation, and you went ahead and did it. So again, you're just saying what you need to say and doing what you need to do to escape by probation. That's not going to work. You don't want to miss any more of your children's lives. Well, you can miss 3 years of your children's lives. Is that what you want?
No, Your Honor.
Well, you should think of them maybe next time you want to put something up your nose or smoke something. Because that's what's going to happen. If I give you this opportunity to go to NeoCap, that's going to be the last chance. You're not going to come back and say, I relapsed again, I made a stupid decision. Let me go to VA, let me go to Ed Keating Center, let me go wherever. That's not going to happen. Is there anything else you want to address or state?
No, thank you, Your Honor.
You seem to act like this is not just a blip and that you should just be able to walk out of here today. I know that's what you intended on doing. You thought you were just going to be able to walk out of here and get some outpatient treatment at the VA hospital and just continue on. I have no idea why you think that should be what should happen. You did the VA hospital. You did an inpatient treatment program at the VA hospital, and that didn't work. You think I should go backwards and do something less than that? That shows me that you really don't get it or don't want to get it. I've considered all the reports that have previously been prepared. I've considered the performance on probation thus far, the nature of the violations. I've considered what's been said here in court. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. I'll incorporate the findings I made regarding the seriousness factors that were made at the time of sentencing. As for the recidivism factors, I'll incorporate those too, with the additional finding that the defendant has failed to comply with previously imposed sanctions ordered by the court, which does indicate recidivism is more likely. And it further appears the defendant still has a drug abuse problem, but he doesn't get it, doesn't recognize it, doesn't want to recognize it. It indicates recidivism is more likely. At this stage, I easily find prisons consistent with the purposes and principles of sentencing. Whether you're amenable to community control sanctions or not, it's very difficult for me to say you are. You can't even give me an answer as to why you are. But I will give you one last chance, Mr. Barfield. Find you're amenable to an available community control sanction that we have left that we haven't used yet. I'm going to extend your community control sanctions by 6 months. I'm going to order that you serve 30 days in the Lake County Jail additional days. So let's say you're going to serve 42 days in jail with 12 credit. I'm going to order that as soon as a bed's available at NeoCap that you be released from the jail and that you enter NeoCap and successfully complete that program, follow all their aftercare recommendations. Any balance of the jail sentence of the additional 30 days is vacated once you've been released to go to NeoCap. Upon completion of NeoCap, I'm going to order that you return to the jail to participate in the transitional day reporting program for 30 days. Now, you may not have to do this. You probably won't have to do this. But it's a program that helps people make the transition from being locked up to being on their own. Many people, after they get released, have nowhere to go. They have no housing, no work, nothing set up. But if you have housing lined up, you have work lined up, and you don't need that assistance in the transition, I'll vacate those days and you won't have to do them. But it's a good program for people that do need the help, and I put it in place for everybody, just in case you find yourself in that position. Further conditions then will be the same as I've had. You are not to use any drugs or alcohol. You must submit random urine screens. They have to be negative. A positive screen is a violation. You're to attend 3 AA meetings a week, have a sponsor. In regards to those urine screens, you better not bring in fake urine or try to submit someone else's urine or anything along those lines. If you do, you're getting the maximum sentence immediately. You have one doctor and one dentist that can prescribe you medication, one pharmacy where you get those prescriptions filled. Probation needs to know where they are. To attend mental health counseling, take all medications as prescribed. Is there anything else I'm omitting here or should be thinking about?
No, Your Honor.
So, Mr. Barfield, do you understand all the conditions of your probation?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I can and will terminate your probation and send you to prison. It'll be 36 months in prison, which would be consecutive to any other prison term you may be serving at that time or that may be getting imposed at that time. Mr. Fatika, is there anything else for the record?
No, thank you.
Your Honor,
Morning.
we're here in case 24 CR 651. This is case caption State of Ohio versus Cody D. Griffith. Present in court is a defendant who's accompanied by his attorney, Mr. Antonio Nicholson. We are present today on a 4-count indictment that was filed on June 28, 2024. It is the state's understanding that the defendant is prepared to withdraw his previously entered plea of not guilty and enter a plea of guilty to count 1, possession of heroin, a felony of the 5th degree, as well as count 2, possession of cocaine, a felony of the 5th degree, with a voluntary forfeiture of all drugs, packaging, paraphernalia, and or other items seized by law enforcement. The state would move to dismiss the remaining counts at the time of sentencing. There is no recommendation regarding sentencing, and the state would request a pre-sentence investigation report as well as a drug and alcohol evaluation. Thank you, Your Honor.
Thank you. Mr. Nicholson, is that accurate?
Yes, Your Honor. After full exchange of discovery with the state of Ohio, it's my client's intention at this time to retract his former enter plea of not guilty and enter pleas of guilty to the plea agreement and the marks that were just, and the counts that were just placed on the record, Your Honor. No threats or promises have been made. Thank you.
Thank you. Mr. Griffith, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
They indicated to court they believe it's your desire to withdraw your previous entered pleas of not guilty and enter plea of guilty to counts 1 and 2. The remaining 2 counts would get dismissed pursuant to the agreement. We would defer, continue the sentencing to a later day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do here at this time?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to be assured you understand what it is you're charged with and pleading guilty to, the rights you have that you're giving up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I am going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you would like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. All right, well, let's get started then. How old are you, sir?
32?
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
Just trazodone for sleeping and comfort meds.
What's that?
Just comfort meds.
What else? Trazodone?
Trazodone as part of the comfort meds, yeah.
What do you mean it's part of it?
They gave me trazodone to sleep for comfort meds, that's all. I don't.
Okay, so that's the only medication?
Yeah, that's
though?
it, yeah.
Oh, it made it sound like there were others.
No, I'm sorry.
Okay.
I'm sorry.
When's the last time you took that?
It would have been last night.
Are you under the influence of that medication right now in any way which is making it difficult for you to understand or appreciate where you are, or what's going on, or communicate or anything like that?
No, Your Honor.
Now, you would have been served with a copy of the indictment in this case back, it looks like probably the beginning of July. That's the document that sets forth the specific charges you're accused of committing. Do you remember getting that at some point?
Yes, Your Honor.
And you had a chance at some point to look that over?
Yes, Your Honor.
Now, in that indictment, you're charged with 4 counts. You're pleading guilty to the first 2, and what's alleged in count 1 that you'll be admitting to is on or about December 18th, 2023 in Willowick Lake County, Ohio, that you did knowingly obtain, possess, or use heroin or some compound mixture, preparation, or substance containing heroin, which is the amount did not equal or exceed 1 gram, which makes the offense possession of heroin a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, count 2 alleges on that same day, December 18th, 2023, in Willowick Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. That amount involved did not equal or exceed 5 grams, which makes this offense, possession of cocaine, a felony of the 5th degree as well. Do you understand what you're charged with and pleading guilty to in count 2?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, there are 2 other counts of this indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about either of those charges?
No, Your Honor.
Well, then before I can accept your guilty plea to counts 1 and 2 that I just read to you, I need to make sure you understand all the rights you are giving up by pleading guilty. And you first of all have a right to a trial. And a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of the charge, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, I speak of this burden of proof since it's a criminal case we're dealing with. The burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would be calling witnesses to come to court to testify for the state by answering questions from the prosecutor. Now, once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that is called cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she would not be allowed to call you as a witness at your trial and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty of any of these charges, you'd have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
You understand them all?
Yep. Yes, sir.
You still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court.
Yes, Your Honor.
Hang on, sorry.
Oh, sorry.
And that you will subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as possible sentencing goes, you're pleading guilty to 2 felonies of the 5th degree. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, Your Honor.
Now, since there are 2 separate offenses that you're pleading guilty to, if I determined that a prison sentence was warranted, I would impose a prison sentence in each count, and then as the judge, I would have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means you serve them together at the same time.
Right.
Consecutive means one after the other. You'd serve the prison term on count 1, whatever it is, complete it, then serve the prison term on count 2. You understand the difference there?
Yes, Your Honor.
So in this case, if I impose the maximum sentence on each count that you're pleading guilty to and ran those terms consecutive, you're looking at a maximum possible prison sentence of 2 years in prison. Do you understand that?
Yes, Your Honor.
Now, are you currently on probation or parole to any other courts or agencies?
No, Your Honor.
Do you have any other charges pending against you at this time?
I believe I had a misdemeanor 4 in Willoughby.
Okay. Any felonies pending anywhere?
No, sir.
If a prison sentence were imposed in this case upon your release from prison, you could be placed in what's called post-release control. We sometimes call that parole. What that is, it's a period of supervision you would be on after you completed the prison sentence. And in this case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control at any point, never violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each separate violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, in addition to the possible prison sentence, there are other sanctions I could order. I could fine you in this case up to $2,500 on each count, so a possible fine of up to a maximum of $5,000. I could order that you pay court costs and also order that you reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Give me 1 second, please. Other possible sanctions, I could suspend your driver's licenses in this case for up to 5 years. It's not mandatory, but I could do that. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory or required in this case. You are eligible for probation, or what we call community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you will automatically be put on probation? It means I'll consider that if that's what you're going to be requesting. I'll look at all the information that gets presented to the court. Then I'll make the decision that I think is ultimately the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as a judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. Do you understand that?
Yes, Your Honor.
Further, if you are put on probation and you're violating the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, again, it could be anywhere between 6 to 12 months on each count. It could be consecutive, so possibly 2 years in prison. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all for me regarding the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer and have him go over everything with you and answer your questions?
Yes, Your Honor.
Are you satisfied with his advice and counsel?
Yes, Your Honor.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right, then. Any questions for me for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your actual plea?
No.
All right, then what's going to happen at this point is the prosecutor is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I'm going to have some questions for you about that, all right? Ms. Simmeline?
Thank you, Your Honor. If this matter proceeded to trial, the state would prove beyond a reasonable doubt that on December 18th, 2023, in the city of Willowick, Lake County, Ohio, Willowick police officers observed the defendant driving a vehicle with no rear license plate illumination, and a traffic stop was initiated. Defendant consented to a search of his person and his vehicle. Upon a search of both, police recovered burnt pieces of foil, folded paper, 2 syringes, a straw, and a piece of metal. All of those items contained powder residue on them. They were all sent to the Lake County Crime Lab for testing. The Lake County Crime Lab did confirm that all of those items contained either or both heroin residue and cocaine residue, both Schedule II controlled substances.
Thank you. So, Mr. Griffith, were you able to hear what the prosecutor just had to say regarding what she believes the facts would show if we did have a trial in this case?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as she just related them to the court? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then, regarding count 1, charging you with possession of heroin, a felony of the 5th degree, what is your plea to that count?
Guilty.
Regarding count 2, charging with possession of cocaine, also a felony of the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which explains everything we've just talked about.
Right.
Before I can accept your plea, I need to make sure you understand what's in this document and that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Nicholson, is that accurate? Did you review this document and read it over with your client?
Yes, Your Honor. I reviewed the documents in its entirety. I reviewed it with my client, explained the rights he was giving up, explained the rights that he had, his trial rights, Your Honor. He executed the document in my presence. I executed the document, and then I gave it to the state of Ohio, in which state of Ohio executed it, Your Honor. Thank you.
Is that correct, Mr. Griffith? You went over the document with your lawyer?
Yes, Your
And
Honor.
you understand it?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
He also indicated that you signed the document. Did you in fact sign it?
Yes, Your Honor.
You also witnessed that, Ms. Emmeline?
Yes, I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, possession of heroin, a felony of the 5th degree in violation of 292511 of the revised code, as well as count 2, possession of cocaine, also a felony of the 5th degree in violation of 292511 of the revised code. I will defer sentencing, order a pre-sentence report and investigation, drug and alcohol evaluation, and bond will remain revoked. Is there anything else for the record, Ms. Hemmeline?
No, Your Honor.
Mr.
Your
Nicholson?
Honor, could you also order a psychological
We
evaluation?
do a psychological evaluation as well. You got that, Mr.?
Yes, sir.
Okay. Anything else?
No, Your Honor.
No, Your Honor.
All right. Thank you all.
present in the matter of State of Ohio versus Jesus Sanchez Pacheco, case number 24CR000054. The defendant is present with defense counsel Justin Weatherly. Yesterday afternoon, September 5th, 2024, the State of Ohio filed a motion for leave from this court to enter a nollie on the case for the reasons that based on some newly discovered evidence as of yesterday afternoon, the state has realized that the case does require further investigation, and the case will be referred back to the Grand River Police Department for said further investigation. I did advise defense of this yesterday afternoon as well. I don't believe defense has an objection to the nollie being entered at this time. Thank you.
Mr. Weatherly, any comments?
No objection, Judge.
All right, then at this time, the court will grant the state's motion for leave to enter a nollie, court finding that there's good cause being shown for the nollie for the reason that further investigation is needed in order to further pursue this matter. Is there anything else for the record at this time, Ms. Ronick?
No, Your Honor. Thank you.
And, bond is hereby released. Was there bond posted or was it OR?
We did post a bond on this,
Well,
Judge.
the bond is released at this point.
It was owner cognizance.
Oh, was it a recording?
Yes.
Okay.
Well,
That's
whatever
right,
bond
I
was
forgot about
posted,
that.
including owner cognizance, is released. If it was money, you're not gonna be able to get it today, 'cause you have to take a couple of days, but it doesn't sound like there was any money, there's no issue there. But any restrictions that you've had on you are released, so. All right, that's it. Thank you.
Thank you, Your Honor.
Thanks, Judge.
All right, we are present in case 24 CR 508, State of Ohio versus Christian Brooks. We are here on a request made by the defendant, pro se, requesting that a new lawyer be appointed. The defendant sent 2 letters to this court, or 2 pages, 2 separate letters, both received at the same time on August 12th. Court caused these to be filed and scheduled this matter for a hearing, which we're here for at this time. Defendant is here in court. He's with attorney Mr. Antonio Nicholson, state's represented by Assistant Prosecuting Attorneys Adam Downing and Melissa Blake. All right, Mr. Brooks, you sent this request requesting a new lawyer, so I'll let you be heard at this point. What is that you want me to know?
No, I was just asking for a new attorney though, so I can get some help though, and like respect though. Like when it comes to my family and me though, just like it's difficulty. Like I'm not getting to understand. I'm not getting nowhere with my case.
You keep talking about your family. You talk about your family. He doesn't represent your family. He represents you. He doesn't have any obligations or responsibilities or duties to your family. He has responsibilities and duties to you. Go from there. But your letter keeps talking about my family, my family, my family. That he's, and then he doesn't represent your family.
I was trying. That's how I was trying to get in contact with him, like through my family, through his phone. I'm like, I be having them to call him so I can talk to him sometimes when he don't answer the office phone. And like when that's what I was saying with my family, like he get them like disrespectful remarks though. That's what I was saying with my family. But it's just when it comes to my case period though, it's like I'm not getting nowhere. It's like it's disrespect. Like we argue. Like he say like rude things. It's just like I just wanted some help with my case. Like it ain't nothing against nobody. I'm looking for help on my case, and I feel like he not representing me like as he should.
Why do you feel he's not? Give me some instances. What's going on? Why do you think he's not representing you as you should?
Cause the way he be talking, like the remarks he be saying, like things he say out his mouth, like I feel like a lawyer shouldn't say. To be honest, though, like a public defender, though, like how he be trying to threaten me. Like today, he said if I get up on the stand and say something, he like go ahead, cause I can be charged with it. But it's like I'm not lying about nothing I'm saying. Like it's just things like that. He's like he tried to skirt me off of, make me feel like I'm wrong, but like I'm just guilty, and I feel like I just want some help. Like I need understanding. Like I've been in county for 6 months, and like he used to come see me, but once I came to court and signed the town, I haven't seen him. I haven't got nowhere, no understanding. He said because I walked out on him though, but
you did. What did you do?
He said I walked out on him. He came to see me in the county, and I walked out the room. And I said I want a new attorney, and I did though. I told him I want a new attorney though, cause it's like we arguing. Like every time he come see me, it's like it's a debate, it's an argument. Like it's just crazy, and I just wanted some help though. Like he disrespectful. Like to be honest, like it's disrespect though. It ain't no understanding. It's like we always fighting about the case, and I just want to help. I just want understanding. I know I got a serious case though, and I know he probably deal with cases serious than mine though. But it's like it's crazy. Like it just be a lot of fighting and disrespect and argument, going like harsh words though. And I feel like a lawyer, we shouldn't even be on that type of level.
You feel like what's the last thing you said?
We shouldn't even be on no type of level like that. We shouldn't even have to argue, or fight, or communicate with certain words though. I feel like for him to have my case, it wouldn't be like in my best perspective to be him. And we've been arguing and fighting, and he done said things and I done said things. I feel like I just want a new attorney that's gonna appoint me well.
Well, just because you have someone that's a lawyer who represents you doesn't mean they have to agree with every single thing you say. If you're saying something that or wanting them to pursue something which they can't pursue, which in their and I'm not saying it's the case, I have no clue obviously, but in their professional opinion, it wouldn't be wise to pursue, or they can't pursue, it would be unlawful for them to pursue. They're not just going to do it and agree with everything you say. They're going to tell you they can't do it, or why they shouldn't do it, or why they believe it wouldn't be in your best interest to do it. Again, I'm not part of any of this. I don't know what the nature of any of this is. But you say you're arguing. That's not necessarily uncommon if between a client and a lawyer. If there's disagreement between the two, the lawyer isn't automatically just going to agree with everything the defendant says or their position on that. If it's not lawful, if it's not, doesn't make sense, if it's not a wise decision, he's going to, the attorney, he or she is going to let the client know that. Mr. Nicholson, you care to be heard of?
Yes, I
any of
do.
this?
Your Honor, that I don't, first of all, I'm going to address the allegations that I don't answer the phone. And if we got to have a full-blown hearing about this, I'll print all the text messages and mark them as exhibits, and I'll send them into the court. But let's just be real. For the record, his child's mother, Alicia Nicholson, has called me several times. I can't even count. She sent me messages. She sent me several things. I can show you. I've communicated with her several times. So I'm going to call trash on that allegation. In addition to the disrespect, okay, and the not coming to see him, I take very good notes when I represent people for things like this. So I have seen him 1, 2, 3, 4, 5, 6, 7, 8, 9 times since this case has commenced. And not even including the times that I talked to him over the phone before his bond hearing, and I came and saw him at Willoughby Municipal Court when he was in the holding cell. So it's trash for him to say that I haven't gone to see him. Now, let's talk about why after June 12th I haven't come see him. Well, he's right. Every time I go see him and show him the evidence, he disagrees with me. Every time I give him my advice, he disagrees with me. And he isn't. I can't even count the number of times that he's told me he's going to pay for a paid lawyer. Okay? But still, when clients say that, you can't take their word for it because what happens is you get the trial and there's no paid lawyer that's been retained, and then you're stuck. So I continue to work on my cases. Okay, and I've worked very diligently on this case since I was put on the case. I represented him at the first bond hearing. I cross-examined the officer. You can find the transcripts of that. Your Honor, our investigator did endless work on this case prior to him even being indicted. Okay, we got pictures, we have multiple witness interviews, things of that nature. Okay, but I haven't been working on this case. Cool. In addition to that, Your Honor, I have had 4 attorneys call me. Private attorneys call me, telling me that he wants to hire new counsel. Okay, I had an attorney call me just as recently as this week, saying that his girlfriend, his child's mother, is very serious about hiring me, and she's going to bring me $5,000. I said, well, when is this going to happen? Because I've heard about this 3 other times. She said he should be by Monday. Cool. Did I stop working on the case? No. In addition to that, on June 12th, I think it was the 9th time I visited him. And some of these visits are like over an hour, Your Honor. And I'm the most accessible person. Well, I won't say that because all of our lawyers are accessible, very accessible. But I'm one of the only attorneys in our office that gives out my private cell phone number because I know I'm not always in an office. I'm either in a jail, I'm either in a trial, or doing other things. So I gave him and his child's mother my personal cell phone number, and I have taken several calls from him and his child's mother. Now, I will say, when he wants to get into details, I tell him, look, we probably shouldn't talk about this over the phone because it's recorded. It's not in your best interest, okay? And if he does get in some type of detail, I hang up the phone immediately because I care about him. This is my client. I don't want him to say something that's going to incriminate him that can be used against him should we go to trial, okay? So I'm not doing that out of disrespect. I'm doing that to protect his interests, okay? I don't know what lawyers he's been represented by in the past before he came to Lake County, but I'm a damn good attorney. I'm a damn good attorney. And I take offense to everything that was put in this letter. I have never, ever, I'm sorry, Judge, but I got to address this.
I get it, but just...
Okay? This is my license on the
I get it, but just...
Okay? I have never, I'll lower my voice, I'm sorry. I have never, ever indicated to this young man that I had any intentions on getting off this case. I have put in hours of work on this case. You should see the phone dumps that we got from the state of Ohio. It is voluminous, and I've gone through it. So, I take offense to everything that was written in this letter. Now, have there been disagreements? Of course. Is this the first client I've had a disagreement with? Of course. And while he's making
Of course,
out,
I mean, no.
well, is it no? Is this the, I'm sorry. Is this the first client that I've had a disagreement with? No, Judge. I try serious cases. This is what I do. I'm a trial attorney. I'm not a cop-out lawyer like some people think. I'm not a public pretender. I'm not a fake lawyer. You want your trial, you get your trial with me. I try cases. So, look, I understand. He's never met a lawyer like me. He's never met a lawyer as passionate about my craft as I am. And hey, too bad, because this is what he got. And to tell you the truth, Judge, he should be lucky that he got this office to represent him, because this office works tirelessly for all of our clients. Now, look, I am not and will not be filing any motions to withdraw this case and waste all the hours and resources that our office put into this case.
Well, it wouldn't be granted anyway, so.
Right. So, but, like I said,
All right.
I don't have any,
Listen,
I don't have nothing else to say.
Mr. Brooks, you have the right to
So-
have an attorney appointed to represent you if you can afford to hire one for yourself, but you don't have the right to pick and choose your lawyer. Mr. Nicholson is a very experienced lawyer, a very good lawyer. He's good at what he does, and you've provided me no grounds to believe otherwise, that he's not doing and working on this case. So your request to have him removed from the case is denied. The public defender's office is appointed to you. They assign who they, whatever system they use to assign cases. And I'm not going to order that a different public defender be put on your case. If they decide that's how they want to do it, that's up to them. But the Lake County Public Defender's Office is representing you in this matter. Mr. Nicholson's been appointed, and I'm not making any orders to change that, because there's been no valid reasons why that should be done in this case. With that said, the last time we were here after a pretrial, Mr. Downing, was back in April, where you indicated that you weren't prepared to present an offer at that time. What is the offer that's being presented?
I believe it was June 6th was the pretrial.
Yeah.
Or I'm sorry, June 7th.
I wrote April, but it was June. I'm sorry.
So we had this pretrial in chambers back on June 6th, and you're correct. The
June
state,
6th?
I'm sorry, June 7th.
Okay.
I'm reading my notes wrong. June 7th in chambers, and you're correct that the state did not have an offer at that time because this is a case.
I know you were investigating certain issues.
Yes,
Self-defense issue.
This is a case where I think there are some legitimate issues that should be
I get all that.
discussed.
I get all that. I don't want to repeat that, but it's been 3 months now. So,
There's been no negotiation. I've been
is there an
waiting-
offer the state is making?
No, because
It's not going to be then?
Well, I'm waiting on a discussion with Mr. Nicholson, and
Well, it's
he's
not.
not had that discussion yet with me.
The state should be prepared to make an offer. They weren't prepared 3 months ago. Literally 3 months ago today, I think, yesterday.
Well, as the state stands now, there is no offer. We're
All
not
right, so
making
the,
an offer on the
state,
case.
so the offer is plea the indictment.
Correct.
Okay.
As it stands right now. If there is a discussion that is had with Mr. Nicholson at some point in the future, that could change. But there's been no discussions with defense counsel since June about the case.
All right, well, we have a trial scheduled for when?
I think it's the 22nd, Judge,
Of,
October. There's a plea deadline
so the
of
plea deadline would be October 8th.
Yep.
So, not extending this at all, and nothing's being continued. So if you guys are going to try to negotiate, you should speak with one another.
Your Honor, if I could place one more thing on the record. Mr. Downing is right. I don't want him to take the brunt of this, because we've had several discussions. However, at that time, my client didn't indicate to me that he would be, it wasn't indicated to me that he wanted to resolve the case. However, I had a discussion with my client yesterday, and he has authorized me. I wanted to wait until we saw what happened today with his motion, whatever he was asking for. But he has authorized me to at least begin discussions, Your Honor.
Well, that's
So-
between you guys. I don't get involved in that. But
I just wanted to apprise the
I
court.
appreciate,
didn't
but
want
if it's
to
something you're
involve-
going to do, you need to sit down and talk about it. So, anything else for the record at this point, then,
No, Your Honor, thank you.
Mr. Nicholson?
Nothing, Your Honor.
Mr. Anything you want to put on the record, Mr. Brooks?
No, sir.
All right.
We're hearing case caption State of Ohio versus Dennis G. Sanders II, case number 24, CR 000984. And information was filed in this case on August 23rd, alleging 4 separate counts. Count 1, trafficking in a fentanyl-related compound, a felony of the first degree. Count 2, trafficking in a fentanyl-related compound, felony of the first degree. Count 3, trafficking in cocaine, felony of the second degree, all those in violation of 2925.03A1. And count 4, failure to comply with order or signal of police officer, that being a felony of the third degree in violation of revised code section 2921.331B. It is the state's understanding today that the defendant will waive his right to have this case presented to the grand jury and enter a plea of guilty to those charges set forth in the information. If that plea is forthcoming and the court accepts that plea, then my understanding is that the defendant would waive his right to a pre-sentence report investigation and that we would proceed directly to sentencing. The state has entered into an agreement with defense counsel that the state would recommend 6 years on this matter. And as discussed in chambers, we will address that at the appropriate time, but it would be concurrent sentences on counts 1, 2, and 3, and a consecutive sentence on count 4. He does have 38 days of credit for time served, and he is present with his counsel, Mr. Chad Mulkey.
Mr. Mulkey, does that all sound accurate?
It does, Your Honor. Moreover, I have discussed all of these issues and options with my client, including Reagan Tokes, Your Honor, and I believe we are prepared to go forward with a plea. Thank you.
Mr. Sanders, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, sir.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'll explain in a moment in more detail what that actually means. And then go ahead and plead guilty to the charges and the information, which I will also review with you to make sure you understand them. We would then, it's been represented, proceed straight to sentencing as there's a joint recommendation that the parties would like to present to the court. That recommendation would be a minimum sentence of 6 years with a maximum sentence of 7.5?
Yes, Your Honor, correct.
So indefinite sentence of a minimum of 6 years, maximum of 7.5 years for all the charges combined. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, sir.
Before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you can ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right, give me 1 second here. All right, let's get started. How old are you, sir?
44.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
Water pill for high blood pressure.
That's it?
That's it.
Now, you should have received a copy of the information at this point. Did you get that? It was filed a couple weeks ago. It's the document that sets forth the 4 charges you're pleading guilty to.
I got some of them. I didn't get the whole thing that we went over, but I read it thoroughly with my attorney when he came and seen me.
Okay, so all right, so you've seen the information, reviewed it, and gone over it?
Yes.
All right, in that information, you are charged with 4 counts. Those are the charges you're pleading guilty to. What's alleged in count 1 and what you'll be admitting to is on or about April 25th, 2024 in Mentor Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. The amount of the fentanyl-related compound was equal to or exceeded 10 grams, but was less than 20 grams. It was specifically 14.38 grams, and it was committed, this offense, this trafficking charge, in the vicinity of a juvenile. That conduct constitutes the offense of trafficking in a fentanyl-related compound. It's a felony of the 1st degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, sir.
Any questions about it?
No.
Count 2 alleges on or about May 20th, 2024, in Mentor Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. The amount of the fentanyl-related compound equal or exceeded 20 grams, but was less than 50 grams. Specifically, is 28.43 grams, which makes the offense trafficking in a fentanyl-related compound a felony of the 1st degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes.
Any questions about it?
No, Your Honor.
Count 3 alleges on May 20th, 2024 in Mentor Lake County, Ohio, that you did knowingly sell or offer to sell cocaine or a compound mixture, preparation, or substance containing cocaine. The amount equal or exceeded 20 grams, but was less than 27 grams. Specifically, it was 26.17 grams. That conduct constitutes the offense of trafficking in cocaine. It is a felony of the 2nd degree. Do you understand what you're charged with and pleading guilty to in count 3?
Yes, Your Honor.
Any questions about that?
No.
Lastly, in count 4, it's alleged on or about May 20th, 2024 in Mentor Lake County, Ohio, that you did operate a motor vehicle as willfully to elude or flee a police officer after you received a visible or audible signal from the officer to bring your motor vehicle to a stop. It's further alleged the operation of the vehicle causes substantial risk of serious physical harm to persons or property, which makes the offense failure to comply with an order or signal of a police officer a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 4?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
So you understand the nature of the charges you're pleading guilty to?
Yes, Your Honor.
Well then, before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. So the charges I just read to you are part of what's called an information. An information is a document that's brought, contains charges that are brought by the prosecutor's office without this case having previously been reviewed by a grand jury. Now what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed criminal offenses. Everybody here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not. And you have that right as well. But you can give up or waive that right if you desire and go forward on the charges brought by the prosecutor and the information, and your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further in that regard, I need to have you acknowledge that here in open court in writing. And I have in my possession here a one-page document called a written plea of guilty and judgment entry, which explains and sets forth what I've just explained to you about the grand jury, and you want to give up that right. Before I can go any further, I need to make sure you understand what's in the document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to review that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Mulkey, is that accurate? Did you read that over with your client and review it with him?
I did.
And did he indicate an understanding of that to you?
He did.
Is that correct, Mr. Sanders?
Yes, it is, Your Honor.
So you understand that document?
Yes, we went over it.
Any questions for me about it?
No.
Now, it appears you signed the document. Did you in fact sign it?
Yes, Your Honor.
Mr. Mulkey, you witnessed that?
I did.
You as well, Ms. Linden?
Yes, Your Honor.
Very well then. I'll make that document part of the record. At this point, I'm going to advise you of all the other rights you have that you give up by pleading guilty. And you first of all have a right to a trial. And the trial can be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, regarding each charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Having the burden of proof means it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of these charges, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence that the state would have to present to prove you guilty. You understand that?
Yes, Your Honor.
So in this case, the state would have to present evidence to prove each element or part of each of these charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes. Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to try to do that, if we're going to have a trial, the prosecutor would bring witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. He could ask him anything he wanted to, within certain rules. Do you understand that?
Yes, yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. And what a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, I do.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here can't call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further, if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all about all these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You understand them all?
Yes, I do.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand your guilty plea of the complete admission of guilt, which means you'll be admitting to the facts being alleged by the prosecutor? We are not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of the guilty plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, pleading guilty to 4 counts. Counts 1, 2, and 3 are what we consider or refer to as qualifying offenses, and all that means is that they were committed after March 22nd of 2019. On that day, the law changed in regards to felonies of the first and second degree. And anybody that commits a felony of the first or second degree after that day is subject to what we call indefinite sentencing. And what indefinite sentencing means, it means that there's going to be a minimum sentence imposed and a maximum sentence imposed, instead of just a stated definite sentence. It's a minimum and a maximum. Now that sentence will only be imposed on the most serious offense of the ones that are felonies of the first or second degree. In this case, there's 2 felonies of the first degree, so they're both the same, so I would just impose it on one of the felonies of the first degree. But in regards to the felonies of the first degree, what the sentence could be is I would select a minimum sentence from anywhere in the range of 3 to 11. So 3, 4, 5, 6, 7, 8, 9, 10, or 11. I'd select one of those numbers for count 1 and count 2, and that'd be the minimum sentence you would have to serve for that count. To determine the maximum sentence, it's a simple mathematic formula. You take half of whatever the minimum sentence is, you add that to the minimum sentence, and that becomes the maximum. So for example, if I took 3 years, half of that is 1.5. I add that to the 3, so the maximum would be 4.5. 3 plus 1.5 is 4. 4.5. If I made the minimum sentence 6 years, half of that is 3. Add that to the 6, so your maximum sentence is 9 years. And I just give several examples just so you understand. If I give you the maximum sentence, that would be 11 years as the minimum. If I chose 11 as the minimum sentence, I would then take half of that, be 5.5. I'd add that to the 11, so your maximum would be 16.5. You understand that?
Yes, sir.
So for counts 1 and 2, you're facing a minimum sentence of 3 to 4.5 years and a maximum sentence of 11 to 16.5 years. You understand that?
Yes, sir.
Now, count 3 is a felony of the second degree, and that's treated the same way as an indefinite sentence, but the range is different. I'd select a minimum sentence between 2 to 8, and then the maximum sentence would be based on whatever I select as the minimum. So in that case, the minimum sentence would be an indefinite term of 2 to 3 years. The maximum would be 8 to 12 years. Do you understand that?
Yes, sir.
Now, count 4 is a felony of the third degree, and it does not require an indefinite sentence. I would impose a prison term of 9, 12, 18, 24, 30, or 36 months. Do you understand that?
Yes, sir.
Now, you are pleading guilty to 4 separate offenses, and the counts 1, 2, and 3 all require a mandatory prison term be imposed for that. So I have no discretion. The term is going to be a mandatory term. You understand that?
Yes, sir.
Count 4 is not a mandatory prison term. It's what they call a non-mandatory prison term. You understand that?
Yes, sir.
Now, since there are 4 separate offenses, I'll impose a prison term on each count, and as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. This is for counts 1, 2, and 3, the 3 drug trafficking charges. Concurrent means you serve them together at the same time. Mm-hmm. Consecutive means one after the other. You'd serve the prison term on the first count, serve that, and the second count and the third count. You understand the difference there?
Yes, I do.
Now, count 4, the fleeing and eluding charge or failure to comply charge, requires that if a prison sentence is imposed, that it be served consecutive to any other prison sentence that's ordered. So that count would have to be consecutive to any other prison sentence imposed in counts 1, 2, and 3. Do you understand that?
Yes, I do.
So in this particular case, I am required to make sure you understand the maximum sentence that you're facing that I could impose. If I gave you the maximum sentence on each count and ran them all consecutive, the sentence you face is an indefinite prison term of a minimum of 33 years and a maximum of 38 and a half years. Do you understand that?
Yes, sir.
And that would be, just so the record's clear, 11 to 16 and a half years on one of the felonies of the first degree, another 11 years on the other felony of the first degree, 8 years on the cocaine charge in count 3, and then another 36 months or 3 years on the fleeing and eluding charge. All consecutive would be 33 to 38 and a half years. You understand that?
Yes, sir.
Now, the minimum sentence that you face, just so you're clear on that, is that the court cannot impose anything less than this, would be an indefinite prison term of a minimum of 3 years and 9 months and a maximum of 5 years and 3 months. So that's going to be the minimum sentence that gets imposed in this case. You understand that?
Yes, sir.
And then obviously there's all different ranges in between there. You understand that?
Yes, I do.
Now, my understanding is you were on post-release control when this occurred?
Yes.
You're still on post-release control?
Mhm.
As the sentencing judge in the new case, if someone commits let me back up. If someone commits a felony while they are on post-release control, the judge who's handling the new case, doesn't matter if that judge was involved in the prior case or not that you're on parole for, post-release control for, the judge that's handling the new case does have the ability or discretion to terminate your period of post-release control and impose an additional prison term of either 12 months or the amount of time you have left on post-release control, whichever is greater. How much time do you have left, approximately?
Probably like a year, I think.
Okay. Well, if it's more than a year, I can give you up to that amount of time.
Mm-hmm.
If it's less than a year, I would give you have to be at least the 12 months. It's not mandatory, and I'm not required to do it, but I have the discretion to do that. Do you understand that?
Yes, I do.
And if I did that, it would have to be consecutive to any other prison term imposed for any of the 4 charges that you're pleading guilty to. Do you understand that?
Yes, I do.
Do you have any other charges pending against you right now?
I got a case in Cuyahoga.
Those are felony charges?
Mm-hmm.
All right, there's nothing I can do with that, and I cannot run my prison sentence concurrent or consecutive to that because it's pending still, right? You haven't been sentenced yet?
No.
Okay. So I'm not allowed to impose a prison term and run it concurrent or consecutive to some possible future unknown sentence. It's got to be already imposed. You understand that?
Yes, I do.
Now that judge, if you ultimately were convicted and sent to prison, could run the prison term concurrent or consecutive to my sentence. In fact, it would have to be consecutive to the fleeing and eluding charge at least. But not, you understand all that?
Yes, I do.
Okay. But you understand I can't order that ahead of time.
I know. I understand.
Now, in regards to the indefinite sentence I'm imposing, again, it's going to be imposed on the most serious offense. What that means is that there is a presumption that after you've served that minimum sentence, whatever it is for that count, that you would be released from that term at least after you've served that minimum sentence. Now, if there's other terms to be completed, you have to do those. But there's a presumption that you'd serve the minimum sentence and be done with the term on that count. Now, that's not guaranteed. The parole authority, if while you are in prison you misbehave, you commit infractions of the rules, they determine that you're not rehabilitated, they could have a hearing to try to keep you in longer, up to the maximum sentence, whatever it is. You'd have the right to have a hearing. If they'd establish that you did engage in bad behavior while you were in prison, you would not be released at the conclusion of the minimum sentence. They would pick a new date for you to be released, in which there'd be a presumption that you'd be released at that time, unless, again, you continue to misbehave. Understand that?
Yes, I do.
Under no circumstances, however, can you be kept in longer than whatever the maximum sentence is for that count. So even if you misbehave the entire time, after you've served the maximum sentence, you'd be done with the term on that count. Do you understand that?
Yes, I do.
I also need to advise you that since the prison term you are serving on the felony of the first and second degree counts 1, 2, and 3 is mandatory, that you will not be able to earn what is referred to as good time credit. Do you understand that?
Yes, I do.
Also, since it's a mandatory sentence that you're serving, you will not be eligible to request judicial release. Do you understand that?
Yes, I do.
You know what judicial release is?
Yes.
You also understand that you're not eligible for probation or what is referred to as community control sanctions, and that prison term of at least, as I mentioned before, indefinite term of 3 years to 9 months to 5 years and 3 months will have to be imposed. You understand that?
Yes, I do.
Now, in regards to counts 1 and 2, upon your release from prison, you would be placed on post-release control for this case. Regardless of if I terminate it or not, it will be irrelevant to that. For this case, you'd be facing a mandatory term of post-release control for a minimum of 2 years up to possibly 5 years. Do you understand that?
Yes, I do.
Count 3 carries with it mandatory post-release control of at least 1 year up to 3 years. Do you understand that?
Yes.
Now, in addition to the prison terms I've just explained to you, there's other sanctions that could be ordered. There's mandatory fines I'm required to impose on counts 1, 2, and 3. For counts 1 and 2, a mandatory fine of at least $10,000 will be imposed for each of those counts. You could be fined up to $20,000. Do you understand that?
Yes, Your Honor.
Count 3 is a mandatory fine of at least $7,500 that has to be imposed. You could be fined up to $15,000. Do you understand that?
Yes.
And count 4 requires that doesn't require actually, I'm sorry, it's not mandatory, but a possible fine of up to $10,000. You understand that?
Yes, I do.
So in this case, there's a mandatory fine of at least $27,500 that has to be imposed, and you could be fined up to $65,000. You understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes, Your Honor.
Further, in regards to counts 1, 2, and 3, I'd have the discretion to suspend your driver's license for up to 5 years. Do you understand that?
Yes.
Now, in regards to count 4, a mandatory driver's license suspension is required to be ordered of at least 3 years, up to possibly a lifetime revocation of your license. Do you understand that?
Yes, Your Honor.
You know, on this form, it says, Ms. Linden, that I may be subject to a license suspension of up to 5 years. It doesn't mention anything about a license suspension for count 4 that I just advised them of.
I just realized that in looking at that, I don't think that that was considered. Do you want me to write that in and have the defendant then
I mean, I'll have to.
initial it? I think he was just looking at the drug charges, Your Honor.
I mean, this is
Yep.
a plea form for all the counts.
Yep.
So you understand, Mr. Sanders, that I will have to suspend your license for at least 3 years, and it could be a lifetime revocation.
Yes.
Finally, when we proceed to the sentencing hearing in this case, you're going to have the right at that time say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf and recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, I do.
Do you understand that whatever the lawyers have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions for me then regarding the potential penalties you face by pleading guilty or anything that we've discussed regarding the indefinite sentence or anything like that?
No, sir.
You understand all the possible consequences and what can happen?
Yes, I do.
Again, you understand you're not eligible for probation or community control sanction, that a mandatory prison term must be imposed?
Yes, I do.
Very well. Do you still want to plead guilty to these charges then?
Yes, Your Honor.
Have you had the opportunity to discuss this case with your lawyer and him go over everything with you and answer your questions?
Yes, I did.
Are you satisfied with the advice and counsel of your lawyer?
Yes, I am.
Has he or anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, I haven't.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering your plea freely and voluntarily?
Yes, I am.
All right, then what's going to happen at this point? Well, let's strike that. Let me first ask you. All right, do you have any questions for me then at this time regarding anything we've just talked about?
No, you were very informative.
Do you need any more time to talk with your lawyer before we go forward with your plea?
No, I'm fine.
All right, then what's going to happen now? The prosecutor is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to what she says because I will have some follow-up questions for you, all right?
Yes, sir.
Ms. Linden?
Thank you, Your Honor. Had we proceeded to trial, the state would have submitted evidence to show beyond a reasonable doubt all those elements that are set forth in the information in counts 1, 2, 3, and 4. Count 1 dealt with a buy from a confidential informant. This occurred at the Great Lakes Mall where there were children present. The fentanyl-related compound that's listed in there was tested by the Lake County Crime Lab, found to be less than 20 grams, that specifically being 14.38 grams of Schedule II controlled substance. Regarding counts 2 and 3, those occurred on the same date. It was an attempted buy bust, and why I say attempted is what leads to count 4. On that specific date, there was also a buy setup, and that was going to be at the Great Lakes Mall for both of the items that are listed, that being the fentanyl-related compound, less than 50 grams being 28.43 grams, and equal or exceeding 20 grams of cocaine, but less than 27 grams, that being 26.17 grams, again, tested by the Lake County Crime Lab. They attempted to stop the defendant. He did take off westbound on 84. The report indicates that it's at speeds of up to 80 to 90 miles per hour south on Broadmoor Road to State Route 2, that the defendant nearly collided with multiple vehicles, and that the chase was terminated later for safety reasons.
Mr. Sanders, were you able to hear what the prosecutor had to say regarding what she believes the evidence would establish if we did have a trial?
Yes, Your Honor.
And what, if anything, do you have to say about those facts? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then regarding count 1, charging you with trafficking in a fentanyl-related compound in the vicinity of a juvenile over 10 grams, what is your plea to that?
Guilty, Your Honor.
In regards to count 2, charging you with trafficking in a fentanyl-related compound, felony the first degree, and that the amount is over 20 grams, what is your plea to that?
I plead guilty, Your Honor.
In regards to count 3, charging with trafficking cocaine, a felony of the second degree, with the amount being over 20 grams, what is your plea to that?
I plead guilty, Your Honor.
And lastly, in regards to count 4, charging with failure to comply with an order or signal of a police officer, a felony of the third degree, what is your plea to that?
Guilty.
All right, I have in my possession here a document, a 7-page document that explains everything I've just reviewed with you. Before I can accept your plea, I need to make sure you understand what's in this document, that you sign it here in open court. I am going to hand it back to you, however, because I did add something on page 3 in regards to the license suspension, which mentioned that there's a possible 5-year suspension for the drug charges in counts 1, 2, and 3, but there is a mandatory suspension that I want to make sure you acknowledge, because we've talked about that, and you understand that, correct?
Yes, sir.
So, Mr. Shadow, if you can hand that to Mr. Mulkey to go over that with his client and have them both initial that, please.
Yes, sir.
Same, okay? Thank you.
All right, so I have in my possession again this document. My understanding is you reviewed it with your lawyer, is that correct?
Yes, yes, Your Honor.
Mr. Mulkey, did you review this with your client before I came out here?
Yes, Your Honor.
And you read it over all in its entirety with him?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Sanders?
Yes, Your Honor.
Do you have any questions for me about anything that's set forth in this document?
No, sir.
Now, it appears that you signed it a couple times, last page and then nothing else. Oh, no, you didn't sign the last page. You guys need to sign that too.
Want to stand up, please?
Make sure you sign this. So it appears that you signed this document. You just signed page 7 just now, but you previously signed or placed your signature on page 5. Is that correct?
Yes, sir.
Mr. Mulkey, you witnessed those signatures?
I did, Your Honor, and we did go over the sentencing chart on the last page, Your Honor. I apologize for the oversight for the signature.
Ms. Linden, did you witness the first signature at least?
Yes, Your Honor.
Very well. The court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas and find the defendant guilty of counts 1 and 2, trafficking in a fentanyl-related compound. Each felony is of the first degree in violation of 2925.03A1. Count 3, trafficking in cocaine, a felony of the second degree in violation of 2925.03A1. And count 4, failure to comply with an order or signal of a police officer, felony of the third degree in violation of 2921.331B. Is there any reason at this time, Mr. Mulkey, that we should not proceed with sentencing?
No, Your Honor.
Is there anything you want to say on behalf of your client?
Yes, Your Honor. I would respectfully ask the court to follow the agreed sentencing recommendation reached between defense and the state in this matter after discussing that with my client as well, Your Honor. He understands there were very serious charges at play here, very serious actions that brings him into the court today, Your Honor. I believe that that recommendation of a 6 years, or 6 to 7.5 years with Reagan Tokes would give him time to take advantage of any offerings at the correctional facility to take advantage of to improve his life with the hopes that he comes out more educated, more aware of what he did to adequately protect the public from future harm, give him time to realize all of the consequences that go with charges of this nature, Your Honor. In that regard, Your Honor, I would ask the court not to impose any additional time due to the parole of his past charges, Your Honor. As it relates to the driver's license suspension, Your Honor, this always gets to an interesting point because we ask for the minimum suspension. That would be while the time that he's serving in prison and not really giving him any sort of meaningful suspension for after he gets out. So I would ask the court and not make that argument to the court to make that suspension meaningless, but I would also ask and understand that the court has the power to take this man's driver's license away for the rest of his natural life. Therefore, Your Honor, I would ask the court, when considering the imposition of the license suspension, to impose a 9-year suspension. I get that number from that's 3 years. If the court were to follow the 6-year recommendation for prison, that still gives him 3-year license suspension after he leaves the facility, assuming he doesn't get any additional time based on the Reagan Tokes, Your Honor. So to make that suspension meaningful, Your Honor, I would ask that to overlap some of the time that after he's released from prison, Your Honor. So that's all he was remorseful. He did plea at the earliest opportunity. That's why we're here by way of information rather than a grand jury indictment as well, Your Honor. Thank you.
Mr. Sanders, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Just the fact that I am remorseful and I wanted to get this situation rectified and at least try to get my life back on track the proper way. That's all I have to say, Your Honor.
Thank you. Ms. Linden for the state.
Thank you, Your Honor. Your Honor, in fashioning the sentence, we would just ask for 3 years on each of the counts, that counts 1, 2, and 3 run concurrent to one another, and that count 4 would be consecutive. He does have 38 days of credit for time served. We did, when this recommendation was made, we were aware of the APA holder and the Cuyahoga County holders as well as his history. He does have a long drug-related history in this particular case. It's the same type of behavior, but we do believe that 6 years addresses that. The 6 to 7.5 years would address that appropriately, along with my understanding is that there's a voluntary forfeiture of all the contraband narcotics in this case, and then the requisite driver's license suspension and mandatory fine.
Thank you. All right, the court has considered the facts and circumstances of the offenses involved here as they were related to the court during the plea, the nature of these offenses. Consider everything that's been said here today. All this is considered by the court in light of purposes and principles of felony sentencing set forth in 29-29-11. As for the seriousness factors, set forth in 29-29-12. As for count 4, the court will note that there were multiple moving violations. The defendant was driving the vehicle at 80, 90 miles an hour on Route 84, which is extremely dangerous. Makes it more serious than normal. For the drug charges, obviously there are large amounts here, but that's reflected in the degree of the offense itself, so it doesn't make it any more serious than a normal F1 or F2. As for recidivism factors, the court finds the defendant was on post-release control at the time he committed the offense. He's previously served a prison term. He has not responded favorably to previously imposed sanctions. Factors indicating recidivism is less likely. I mean, I've nothing really much to base it on, but there appears to be genuine remorse. He's been here in front of me at this time, very respectful. He obviously pled out immediately, so I'll make that finding. The court also finds that counts 1, 2, and 3 are all subject to mandatory prison terms. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, the defendant serve an indefinite mandatory prison term of a minimum of 3 years, a maximum of 4.5 years. On count 2, the defendant serve a mandatory prison term of 3 years. On count 3, the defendant serve a mandatory prison term of 2 years. Those 3 counts will all be served concurrent to each other. On count 4, the defendant is hereby ordered to serve a prison term of 36 months, which shall be served by law pursuant to 2921.331, consecutive to the prison terms I just imposed in counts 1, 2, and 3. So there's an overall prison term, indefinite prison term of 6 years, minimum, maximum 7.5 years. I will give him credit for 38 days he's already served. Counts 1, 2, and 3 each require a mandatory fine of at least half of the maximum fine. So I'm going to impose a mandatory fine on count 1 of $10,000, mandatory fine of $10,000 on count 2, mandatory fine of $7,500 on count 3. I am going to suspend the defendant's driver's license on count 4 for a period of 10 years. The defendant's ordered to pay all costs incurred in this action. I also need to advise you that upon your release from prison, you will be placed on post-release control. It's mandatory in this case. I'm not doing anything with your current post-release control. So whatever happens with that, happens with that. I'm not terminating it. But in this case, upon your release, you'll be put on post-release control for at least 2 years. That's the minimum, which is mandatory. It could be up to 5 years. On post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Lastly, I do need to advise you, I just told you about this shortly ago, but I'm required to do it again. Then in regards to the indefinite sentence that was imposed in count 1, there's a rebuttable presumption that you will be released after you've served that minimum sentence on that count. You're going to serve the definite terms before you serve the indefinite sentences. But once you've served the 3 years on count 1, there's a presumption that you will be released. It is rebuttable, which means that the Department of Rehabilitation and Corrections can rebut that presumption if at a hearing they are able to establish that you misbehaved while you were in prison, committed infractions of the rules, that you continue to be a threat to society, you're not sufficiently rehabilitated. If they establish that, then they will not release you at that point. They will select another day for you to be released in the future. There'll be a presumption that you should be released on that future day, unless, again, at a hearing they're able to establish and rebut that presumption that you've continued to misbehave and engage in that type of behavior. Under no circumstances, however, can they keep you in beyond the 4.5 years for that count. So even if you misbehave the whole time, they'd have to release you at the conclusion of that maximum sentence and that count. Do you understand that?
Yes, sir.
I think that covers everything. Ms. Linden, is there anything I've omitted or that we need to address?
No, Your Honor, thank you.
Mr. Mulkey?
Nothing that I can think of, Your Honor. Thank you.
All right, thank you.